Welcome, everybody. Glad you're here. Tangled title's a big, important issue and successor and interest. This is we have a really good sign-up list for this, and we're glad you're doing it. I'll be very quick. I just wanted to mention one quick thing in case you missed it. Ellie put out a notice that FHA had opened up its financing to ADUs. So those extra units that might be in the back or as part of the house, and that in the past had not been able to be included in the FHA qualification. So they're now taking income, they're recognizing income or potential income from those units. And another thing that we think is very encouraging and pleased about was that they're also allowing 203K loans to be used on ADUs. So that's something that we had lobbied on and argued for in our whole 203K reform package, and it's a big step forward. There are other improvements. I'll send a note out about this on Monday with a lot more detail so that we can have the tools, but it does really expand the opportunity on ADUs. With that, I'm going to hand it over to Ellie so we can get started.
Thanks, Bruce. Hi, everyone. We have a really stellar lineup of panelists today from National Consumer Law Center, National Housing Law Project, American Land Title Association, and Old Republic Title located in Philadelphia. So we realize there's a pretty important webinar at 2 p.m. Eastern today about the HUD Housing Counseling Handbook. So in the interest of time, I'm going to hand it right over. I'm going to allow the panelists to introduce themselves, and I'm going to hand it right over to Elizabeth Blosser with American Land Title Association and Carrie Mann with Old Republic Title. Take it away.
Thank you so much, and thanks for the opportunity to be part of this webinar. I'm excited to see so many participants from the Pacific Northwest, which is where I live. I am Elizabeth Blosser. I am Vice President of Government Affairs at the American Land Title Association. In that role, I focus a lot on our state legislative efforts, but also our industry strategic priorities. And one of those priorities has been looking at ways to address the issues associated with tangled title and heirs property. We do have a work group that is focused on figuring out how we as an industry can collaborate and advocate for public policy to help the heirs property community. So excited to be talking about this topic. Over to you, Carrie.
Hi, I'm Carrie Mann. I work for Old Republic National Title Insurance Company. I've done both claims and underwriting, so I've seen the tangled title issues from a couple of different sides now. I'm also active in our state association, the Pennsylvania Land Title Association, wherein I communicate with a lot of different organizations regarding tangled title. So we're excited to talk to you today about this. I think it's safe to say both Elizabeth and I are passionate about this particular topic. Slide, please. So here's our agenda for today. First, we're going to start with what is heirs property, meaning what do we mean when we say heirs property or tangled title? What are the challenges that arise when we have these tangled titles, and what harms are done as a result, and what can be done in order to cure tangled titles? Slide, please.
So the first thing we're going to start out with definitions. I always think it's good to start with definitions and be clear about what we're talking about. Our work group has spent quite a bit of time talking about really what is heirs property and what is tangled title. And what you see on the screen is a definition that we came up with that we think applies well. Heirs property is real estate which official government records indicate is owned by someone who is deceased and maybe has been for multiple generations. So when talking about official government records, we're of course talking about local land or property records. And as you'll see, the multiple generations is underlined here. So if you think about it, siblings who've just inherited property from a deceased parent are technically also, heirs to property, and you could see that as heirs property. But what we generally think about as heirs property, especially as it relates to tangled title, is property that has passed hands for multiple generations from the person who was listed in the land records as the owner. And, this is something that becomes confusing because real property is treated differently than other personal effects or financial assets. Once someone has deceased, and so you really kind of have to educate yourself and consumers about the fact that real property is treated differently and looked at differently. So, at the end of the day, if a person's property has not gone through a court proceeding after they deceased, or they didn't use alternative estate planning methods that didn't require a probate proceeding, that property is going to become heirs' property. Next slide.
All right, so we thought it was important to give you examples of a tangled title or heirs property, because as Elizabeth mentioned, we're not just talking about property that it was currently held by a deceased or and is being administered by the estate. We're talking more about things that have happened long in the past and haven't been transferred for some time. So for example, a mother and father purchased the property in 1970. Both parents die. One of their 5 children lives on the property, covering all the carrying costs on the property. But there's never been a deed recorded. So the record title looks like it's just in the mother and father, but there's just one of the 5 children living there who probably thinks he or she has a greater claim to the property than the other children, but it's never come out of the mother and father. So the question becomes, who owns that property? Who has the authority to transfer the property, to mortgage the property, or to take any other benefits? Another example is a grandmother purchased the property in 1957. The grandmother promised the land would go to one of her 3 grandchildren when she passed. But when she passed, the granddaughter records a deed transferring the property to herself without raising an estate or having any other heirs sign off. In many states, in order to be able to transfer property, someone must raise an estate, act as an administrator or personal representative of the estate, and then have the authority under the estate laws to transfer the property. In this particular instance, no such estate was done. So while a deed was recorded, and often those deeds will be taken by the recorders to make them a public record, it doesn't mean that she has title free of the interest of all the other heirs of the grandmother. Slide, please.
So it's important to note that based on state law, a deceased person can have many heirs. And this is something we hear a lot from our members. Again, kind of going back to the fact that personal effects are treated differently. If a person passes away, generally the family that's close by, relatives, friends, sort of take care of those personal effects. Property is completely different. So, you think about the examples that Carrie laid out. You also have to think about, people who are maybe separated but not divorced from a spouse, and what interests might that spouse have? Or if you've had a sibling who's moved away and maybe deceased but had children, and you have no relationship with those children may have an interest in the property, even though there isn't that ongoing relationship with the rest of the family. So it's important to know there can be many heirs, and that each heir does in fact have rights and responsibility that relate to their fractional interest in the property. However, sort of the big issue comes when you realize that all of these heirs that have to be identified and have rights and responsibilities have to agree in order to make a lot of the major decisions regarding the property. Slide, please.
And I would note, we keep saying real property is different. Part of that, in my opinion, is it's different because it's the actual property that gets transferred from one owner to the next. So the next owner who's going to buy it, or the lender that is going to take title to it, they are not going to want to purchase it if they aren't sure that all or lend on it if they aren't sure that all the people that have an interest are signing off. And mostly that is led or driven by our industry, the land title industry, in that when someone goes to buy a home or lend on a home, a title search is done and a commitment to insure title is produced. Basically, what that does is the title company is saying, okay, I'm going to give a policy to either the lender or the buyer, but I need all of these things done before we will agree to issue that policy. So our industry tends to drive that because we are looking to make sure, because we are ensuring the buyer or the lender that they have good title or a lien on good title. We're looking to make sure all of the right people have signed off and been accounted for from day to day. So that leads into what challenges are there out there when we do have these tangled titles or heirs property. So because the official records show a deceased person that owns the property, the heirs might have the inability to finance or transfer the property, as explaining earlier, with the idea that they will not be able to get a title insurance policy, or the buyers or the lenders might not be able to get a title insurance policy if certain things are not fulfilled, like all of the heirs signing off, an estate appropriately raised, etc. And for many of these families, this impacts, I think the greatest impact of the tangled title problem is for families that their biggest asset is the house, is the property. Because a lot of times they just don't think about the other things. There's nothing else to hand down. They think they can just move into it and it'd be done. But by the fact that we're essentially tying up the greatest asset of a family, if we don't have clear title, because they're not going to be able to finance or transfer it. Another big problem we see is an inability to access emergency aid. When the person that is seeking emergency aid is not the owner of the property, that aid's going to be denied. And this aid varies. It could be emergency assistance from a government or a nonprofit organization. For example, many cities have emergency home repair. Many cities and states have emergency home repair assistance, but you have to be able to prove that you own the property. They won't just give it to anyone. Additionally, we've heard from across the country with FEMA funds. FEMA offers funds to help repair properties after a natural disaster, but you still have to be able to prove that you own the property before they will give it to you. And then the ability to make major property decisions is hindered. When you have multiple people that can't agree on something or what to do with the property, it makes it really difficult, again, to tap into that equity. And the issue always, it feels like a lot of times when we're trying to clean up these matters, there's always an error that's unreachable. So yes, they haven't talked to them for years and we can't prove where they are at or find them, but they are still needed for major decisions, such as perhaps putting a mortgage on the property or selling the property. Slide, please.
So when it comes to tangles, time makes everything worse, as you might imagine. So the more time that goes by, the more generations, the more people that may be considered heirs and have an interest in the property. And the interest of those people does need to be protected and thought about. So as time goes by, you can imagine you might go from 3 heirs to 10 heirs to 25 to 50 to 100 plus. And you do see as time goes by situations like that. And obviously, as Carrie mentioned, there's these, unreachable heirs. The probability of having one or more of those increases as time goes by, and that doesn't even take into consideration potentially unknown errors with the more time that goes by. I think too, this is a good time to point out that disproportionately African Americans have been impacted by heirs property. You have seen a lot of stories, especially about Black farm owners and others who've had these tangled title situations, and it's affected their ability to use their property, transfer it, and we're going to go into some more of those harms. And I know, Carrie, that's something that you're well aware of, given your work in the Philly area.
Yeah, in the Philadelphia area, there's actually a Pew research report that talks about the areas that are most greatly impacted by tangled titles, and it is largely in areas of minority communities, that the titles have just not been transferred at all, and so it does disproportionately impact the communities of color and the minority communities, particularly in the Philadelphia area. Slide. So there are various harms that an heirs experience as a result of this problem with their title. I think one of the biggest ones we most often see is the forced sale of the property. It varies. Property law is mostly governed by state law, not necessarily federal law. So how you can transfer property, how you can raise an estate to transfer property, or if you need to, is different in 50 different states. There's 50 different rules. Some might overlap, but in general, there's going to be a different code, different case law that applies to any. So but most states have laws that allow one heir to force the sale of a property by filing an action and saying, look, we are all what's called co-tenants, meaning we all own the property. We can't agree on what to do with the property. So court, go ahead and sell the property, and the court can order that. And that sounds like a great way out of this problem, but often it seems to be an heir that is not necessarily involved with the property, hasn't been living there, hasn't been maintaining it or paying the taxes or paying the bills. And then it's not, so you have a situation where you are forcing people out of their home because perhaps an unscrupulous heir, or we just don't get along. And so I'm going to go ahead and force it. I always say, from an underwriting standpoint, I never want to get involved in neighbor disputes, and I don't want to get involved in family disputes, because those seem to be the costliest and take the longest to resolve, because it's not just about the law and the facts. It's about you can never really reach a great resolution when you have a history of disliking each other. So slide, please.
So a lot of the challenges to heirs property really are around the ability to maintain and use the property. As we talked about, it can be difficult to get the aid that you need, or the financing that you need to make repairs, whether that's due to a natural disaster or just the passage of time. We have been very pleased to see USDA and FEMA make changes to their processes to make it easier for heirs to get aid, and we support that. We support the continuation of that and the expansion of those types of efforts. If you're thinking about things outside of a natural disaster, maybe over time the roof leaks, the windows need repair, the furnace goes out. And if you're looking to get a loan or financing to make those repairs, it becomes challenging when there's unclear ownership, because lenders are going to look at their ability to take possession of the property for if there's failure of repayment of the loan. And as we discussed, it becomes difficult to transfer the property unless all of the heirs are involved. And so unfortunately, what that can lead to is vacant or abandoned property. And so instead of the property sort of creating wealth and opportunity for these family members, it stands empty and unused. Next slide, please.
So then that leads to economic hardship for the heirs. They're unable to realize, essentially, not to sound too cliche, but the American dream, the idea of property ownership and having that property there as a major asset. They lack the ability to finance it, and they lack the ability to transfer the property in ways that allow them to build wealth. Additionally, economic loss. When heirs can't maintain, develop, or utilize the property, it loses its value. And what we see very, very often is a higher risk for fraudulent activities. Deed fraud is a big problem across the country, and it's not just in the major cities anymore. What happens is people looking to steal or take property are looking at the public records to see property that has not been changed hands in years. What the thinking is if it has not changed hands in years, no one is paying attention to the property and would be able to stand up and say, no, that's my property, not yours. So we are seeing it not only in the large cities. It's a big problem in cities that are developing some of their historically poor neighborhoods. There's a lot of redevelopment, for example, in Philadelphia. There's housing booms in some of these pockets that used to be minority communities, where there's tons of property being transferred so builders can tear down the old structures and build something that's much more expensive. Well, that leads to fraudsters who want to make a quick buck, and they will pose as either the owner of the property or they'll pose as an heir of the original owner of the property. So we see that a lot, but we're seeing it too with vacant land outside of cities, and we're seeing it come in through people saying that they're overseas and they want to sell this vacant land. And again, because there is such a demand for housing right now, there's a housing shortage. People are going to make big money on it, and they try and game the system anytime they can. I will say that, to toot our own horns, if you will, we are able to, as an industry, a title industry, we often catch a lot of this before the sales happen. Because we are asked to ensure a transaction and things don't make sense in terms of what people are telling us, but we don't catch it all. And if we haven't, we might catch it 2 or 3 deeds down the road when we finally get to a transaction that is going to be insured. But then you have the problem that there are all these deeds in between. And what do we do now for the heirs, for all these deeds in between? Because you have to get them off of title somehow. Slide.
I'm going to add one more thing too, just for all of you as you're working with your clients who are coming to you. A really smart, practical thing people can do is reach out to their county recorder's office and see if they have free monitoring services they can sign up for to be informed if any documents are filed on record pertaining to them or to their property. Those services are free. And for example, in Arizona and Florida, there was laws passed just this year to mandate that counties offer those services for free for their constituents. So it's a really good way for consumers to stay on top of what's being recorded in the land records.
Absolutely. And that's available, I think, in most states. We have many counties in Pennsylvania and Delaware and New Jersey that's where I primarily work that offer that too. So it's I know I've signed up for it in my county so that anytime anything gets recorded against my property, the county sends a notice out. So then it doesn't stop someone from recording something, but it makes it, as Elizabeth explained earlier, time is not a good thing when it comes to tangled title. The more time that passes, the harder it is. Well, that's the same too of the more time that passes when, for example, a fraudulent deed goes on, the harder it is to unwind that fraud. So excellent recommendation.
Taxes are another issue that comes up for heirs. If you have an heir that's living in the property and their state laws are such that they can't take advantage of homestead credits, that's adding costs and complications for them to be able to reside in and continue to use the property. Additionally, there is a disproportional amount of heirs property that is lost to tax sales over time. And so this is certainly something our industry has been looking into in terms of advocating for some reforms to help heirs in this area.
And
Next
if
slide.
I may add, sorry, go ahead.
Yeah, no, go ahead.
If I may add, I think part of that has to do with who gets the tax bill. If they're sending it to the original person, they're not going to send it to the heirs because they don't know. Who gets the tax bill is largely driven on what the deeds of record says. And I think too, there may be some issues with the ability of the taxing authority to negotiate payment plans on taxes with heirs when they are not entitled to the property. And then displacement and homelessness, as we referenced before, there's the ability of one heir to force a sale of the property. You see the fraud out there too, and they might not have the ability to fight the fraudulent deeds out there. So, and also, and you see this most often, I think, in larger cities that are active in making sure properties are habitable. If they don't have the funds, if they can't access the equity in order to keep the property in a habitable form, they're running the risk of properties being torn down and their ability to actually live in the property. Oh, slide, please. Apologies.
In addition to these, very real harms to heirs, and we know there are more beyond the list we just went through, but those are some of the main ones that we've been focused on. From a public policy standpoint, it's also good to talk about the overall economic harms as well. When you have properties that are being underutilized, not utilized to their highest potential. When you're talking about vacant and abandoned properties, that's also, leading to dwindling property values. And at the end of the day, you just have less real estate on the market. And at a time when there's a housing crunch, from a public policy standpoint, that's something for people to be aware of. And there is some research, for example, in the state of Georgia that indicates that, up to 10% of property there may be heirs property. So you're talking about, in certain places, significant impact to the market. Next slide.
So we've been pretty doom or gloom, I think, about the problem, but there are some things that can be done. I think as we go through these, I think I wanted to make the point that as we are spreading the word, so to speak, about the heirs property, or as people in general are learning more and more about it, part of the issue is the expense of being able to untangle the title or getting with a legal professional that can help you to do that or help the heirs to do that. But I wanted to highlight that as we're seeing that, governments are making provisions for that. So for example, in the Philadelphia region, there's a Tangled Title Fund where we can tap into financial aspects or financial funds in order to help with the clearance of the title. So The first thing that can be done is educational awareness, and I think this is where housing counselors can play a great role in fixing this issue. Is many people don't understand the lack or understand the consequences of not having a deed into their own name. They don't understand that even though they've been caring for this property, or they cared for the person that originally owned the property, it doesn't mean they have the rights to do what they can with the property, and including selling it or taking a mortgage out on it. But more than that is estate planning. So when someone buys a property, understanding now you have a property and you should have an estate. I think almost every adult should have some sort of estate plan, because then they can control where their property goes, rather than being controlled by the laws of the particular state. But making sure people understand that now that you have this property, it's important to develop a plan for what's going to happen to your property when you die. Particularly if the people you're counseling have children, it's really important so that they can benefit from it. And not only that, to have their heirs understand what's supposed to happen. A will is no good unless the heirs know where that will is, and where to go once the will happens. I think there's certainly not enough, but there are a lot of organizations out there that will offer estate planning, particularly for lower income individuals. I think the area where it gets a little tougher is that high, like middle income, where they don't know where to go for and to have their estate planned. And if I can recommend to you, if someone says, well, where do I go? Almost every county has a bar association and has a legal referral system to it. So you can Google the local county bar association and point them in the right direction. You can also Google the state bar association, and a lot of times you can look up attorneys there as well. So really making sure that they understand that they have to figure out, either setting up a deed in a certain way so that it'll automatically go to one person when the other person dies, or actually having a will in place to say where the property is going to go. And as I mentioned, importantly, telling the people that are going to get the property where this will is and where they need to go after they die. And then actually establishing legal ownership. There are a multitude of ways to establish legal ownership, either through deeds from all of the heirs, potentially raising an estate or filing an action to establish who actually owns the property. I'll say that a lot of times as a title professional, we care and want people to benefit from their property, and we're able to offer solutions in terms of, well, we don't necessarily need you to raise an estate, but if we can find all of these people, we're willing to go ahead and ensure the next purchaser. So a lot of establishing legal ownership can be done in a lot of different ways, but it does involve seeking legal counsel. And I think, the funds are starting to get there. It's starting to be known more and more about the problem and the need to address the problem. But it's not quite there yet. So slide, please. So establishing legal ownership, as I mentioned, upon agreement of all the heirs, you can complete either, sometimes you can just do it by one deed. Sometimes you actually have to have a court proceeding. If there are unreachable heirs, meaning we have no idea where they are, they can go to court to get a non-appealable order saying who owns the property. So there are various ways to do this. Slide, please. But it's time consuming and may need assistance of a lawyer. particularly if the situation requires raising an estate or a legal action. We should really work. That's why I wanted to highlight that the title community is a great resource to talk to about, what would you require in order to insure, because we often are the gatekeepers to the transfer to the next thing. And I don't know an underwriter that loves to say no. We like to say yes, and we try to get to a final solution that works for everyone. And then you have to get creative in proving the errors. And I would say in this day and age where it's making it so much better in terms of the internet searches, finding people on social media, there's Find a Grave and obituaries out there. But in order to prove errors, we rely on lots of other things too. We obviously look at death certificates. I've looked at funeral programs. It's or even historical society information. And then there are various paid databases we look at to figure out who is an heir to the property to help people out. Slide. So the basic process for determination of property ownership is identify all of the heirs, either through an established statute or a court process. A determination of the ownership is made by the court, and the property ownership is updated in a government record, either through a court order or a deed or a combination of the two. Slide.
I want to touch real briefly on public policy that's out there. It's been about 10 years ago, the Uniform Law Commission drafted the Uniform Partition of Heirs Property Act. And this act really helps heirs in that it helps ensure that they're getting fair market value if their property that they own in common is sold. As Carrie mentioned, one of the top issues or problems and harms that's caused by heirs property is somebody with a small fractional interest forcing a sale. And in times past, there's been heartbreaking horror stories about people who were tenants in common, the other heirs, people who had maybe been living on the property, caring for the property, farming the property, getting just a small amount of the value of the property compared to what they should have received. So this act does put protections in place. If we can go to the next slide, you can see a map of the enactments. It's been enacted in 23 jurisdictions, and hopefully will be finalized in DC soon, so that will be 24, and we'd love to get to the magical 25. So ALTA, the American Land Title Association, does endorse this act, and as we've mentioned, as we've kind of gone through this conversation, there's other public policy efforts that we're very interested in, whether it's looking at some tax reforms, looking at ways state by state to make it easier and more accessible for people to do estate planning, and then making sure that people have the resources they need to untangle title. And so with that, I am going to turn things over to Lisa and Sarah. Thank you.
Thank you.
Thanks, Elizabeth and Carrie. And I know that Lisa and I are also really happy to be with you all today to talk more about heirs property and tangled title and some of the issues that arise. We are going to focus in mainly on situations where there are heirs and there's also a mortgage loan on the home. And of course, this happens more often. This is an issue when the tangled title situation is only 1 or 2 generations deep. When you get those really tangled titles where there have been many generations of transfers without probate, then typically there is no mortgage on the home. But oftentimes we see homeowners where there has been a death, maybe the person that's living in the home now, maybe it was their mother's home or their grandmother's home, and they are attempting to pay the mortgage loan and keep the home that they're living in. And so those are the issues that Lisa and I are going to talk about for the next part of this presentation. Next slide, please. So we'll talk a little bit about what happens when a home is transferred and there's a mortgage that's still in place. We'll talk about the RESPA rule for successors in interest, which is this special term that we will define, and information about getting a loan modification or half assistance, and then just a few words about bankruptcy, reverse mortgages, and tax foreclosure. Next slide, please. All right, so when ownership of a home transfers and there is a mortgage, in effect, there's something called a due on sale clause, or really a due on transfer clause, that can kick in. And the idea is that this is part of the mortgage contract that allows the lender to call the loan due if the property is transferred without the lender's permission. And so the idea is this is the way that mortgage creditors control who they're dealing with on the other side, and the, you know, in order to be comfortable with credit qualifications of that person, they started to put these clauses in mortgage contracts. And again, they're typically referred to as a due on sale clause, but even if a house is transferred for free or through a death, there is this possibility of triggering the due on sale or due on transfer clause. If there's a mortgage that does not have this clause in it, then the lender would not have any right to foreclose based on a transfer of the home. However, in the United States, just about every mortgage loan has this type of clause. It's the typical way of doing business now for a few decades. Next slide, please. And this is just an example of what that language looks like in this clause in the mortgage contract. And of course, the mortgage or security instrument gets recorded in the deed records, and so it's in that document, not the promissory note, but the security instrument. And it will say, if all or any part of the property is sold or transferred without lender's prior written consent, lender may require immediate payment in full of all sums secured by this instrument. And so they're able to call the loan, and if it's not paid off, then they can foreclose. Next slide, please. And so the use of these clauses had been growing in the United States, and in the 1970s and early 1980s, some states started to say, we don't think this is fair, we don't think lenders should be able to do this, and they started to limit due on sale clauses. And then Congress stepped in and said, we think there needs to be uniformity on this around the country. So they enacted the Garn-St. Germain Act, or the Garn-St. Germain Depository Institutions Act. And fundamentally, what that law says is that due on sale clauses are allowed, that you can put it in the contract and a lender can enforce it. However, they created a special category of transfers that we call the Garn exempt transfers, or Garn-St. Germain exempt transfers, after which a lender cannot exercise the due on sale clause. So it was really a matter of public policy that Congress said, in general, we think this is reasonable. We're going to let lenders do this. But we're going to protect certain kinds of transfers. And these are really the intra-family transfers. So if you look at the bullet points, it's a transfer by devise, descent, or operation of law upon the death of a joint tenant. And that is like when two people own a property together on the deed as joint tenants. So if an ownership transfer passes by the death of one of those owners, that is a special protected category. And then any transfer to a relative resulting from the death of a borrower, a transfer to a spouse or child of the borrower, a transfer to a spouse pursuant to a divorce decree or separation agreement. And there are a couple others. There's one about trusts, estate planning trusts. So basically, these special kinds of family transfers, Congress said a lender may not exercise a due on sale clause after these kinds of transfers. So in general, what that means is if I own a home and I have a mortgage that I'm still paying, if I want to sell my house to Joe Schmo down the street and he has no relation to me, then the lender can accelerate the loan and foreclose if I make that kind of transfer, truly an arm's length transfer. They have to decide if they want to allow that. But if I die and my home is passed to my heirs, or if I get divorced and my home is passed to my ex-spouse, those transfers are special and lenders cannot foreclose on the basis of that type of transfer. Next slide, please. And so what that means is, before I talk about assumptions, just to be clear, what that means is a person who obtains a home through a death or divorce has the right to stay and pay. They can stay in the home and keep making the payments, and as long as they make the payments, there will not be a foreclosure. Now, reverse mortgages are special and different. We'll talk about reverse mortgages at the end. But for most regular mortgages, an heir has the right to stay and simply make the payments. If they do that, they will not be a borrower on the loan. They will just be paying on the loan that is securing the home that they own. And so then sometimes people ask, well, do they need to do an assumption? Do they need to assume the mortgage loan? Assumption is something different. So let's talk about what is an assumption. An assumption is an agreement where a person takes on personal liability for the debt and says, I hereby promise to pay this debt personally, so that if they don't pay, it is possible for the lender to come after them personally. Normally, a mortgage lender will foreclose, but let's say there's a foreclosure and there's a deficiency or shortfall. If the person has assumed the loan, they're personally on the hook for that debt. And it makes them, they basically step into the shoes of a borrower if they do an assumption. However, it doesn't necessarily release the original borrower from liability. An assumption on its own just means I am now joining this contract. I agree to be obligated. Next slide, please. And one thing that I like to explain in these trainings, and the National Consumer Law Center has worked on these issues for a long time. I do want to mention that we are available as a resource. We work with a lot of housing counselors around the country on these issues, and my contact information is in the slides. And so what I like to explain is that the mortgage loan is assumable after a Garn St. Germain transfer, because the due on sale clause is the clause in the contract that would allow the lender to not allow for that assumption. That's what limits this new person's ability to assume the loan. And that doesn't apply if it's a Garn exempt transfer. So they can assume the loan if they wish, and it should be treated as a non-qualifying assumption, which would be different, again, from if I wanted to sell my house to Joe Schmo and it's an arm's length sale. That type of assumption is a credit qualifying assumption, and the lender can say yes or no. Next slide, please. But the important question here too is, does your client want to assume the loan? Because they shouldn't necessarily have to. And if they do, they take on that personal liability, which carries some risk. So if they do decide to assume the loan, the court decisions say there are no necessary or formal words. There's no magic words. Any document that shows that I hereby promise to pay is sufficient. And signing a loan modification could show an assumption. You know, the case law is a little bit mixed, but there's an argument for that. But it does have to be an active step by the heir saying, I hereby promise to pay. Simply making the payments on the mortgage is not enough. And that's really important, right? Because we want people to be able to keep making the payments on the mortgage on their home, even if they don't want to assume personal liability for that debt. So really the important question when you're helping these homeowners is to help them think through, do they want to assume the loan or do they want to just stay and pay? And in order to make that decision, they need information about the mortgage loan. And many times they're better off not assuming the loan, but they've got to be able to communicate with the mortgage company and get information. Next slide, please. And so that is where the RESPA rule comes into play. The Consumer Financial Protection Bureau enacted this rule in 2016. It took effect in 2018. Under RESPA, the Real Estate Settlement Procedures Act, which is a federal law. Next slide. And so what does the RESPA rule do for successors in interest? And I'm sorry, I should define that term. When I talk about successors in interest, we are talking about a homeowner who obtained ownership of a home through one of those family transfers, but was not the original borrower on the mortgage. And unfortunately, as I'm sure you all know, those successors in interest often have a really hard time dealing with the mortgage on the home. They will call up the bank, they will try to make a payment, and they will be told, we can't talk to you, you're not the borrower. And so those successors in interest needed protections. And that's why the CFPB enacted this rule that basically says that when someone is confirmed as a successor in interest, the servicer must provide them information about the loan and treat them as a borrower for purposes of RESPA. And RESPA, which is also enacted by Regulation X, has a number of different rights for people who have a mortgage loan. There's the right to send a qualified written request asking for information about the mortgage or disputing an error. There's a right to apply for a loan modification with certain procedural protections. And there's also servicing rules under the Truth in Lending Act that give you the right to get periodic statements, to have your payments applied promptly, to get a payoff quote, and all of those rules also apply to these confirmed successors in interest. Next slide, please. So just to walk through this definition, a successor in interest under RESPA is someone who an ownership interest of a property securing a mortgage loan has been transferred from the borrower, provided that it is one of these types of transfers. And this will look familiar to you because it verbatim comes from the Garn-St. Germain Act. So the CFPB took those same categories of special protected transfers, family transfers, and said, these are the people that are successors in interest. And it makes sense, right? Because the lender cannot accelerate the loan based on the transfer in these cases. And so we need to let these people get information about the mortgage and deal with the mortgage. Next slide, please. So in order to have the protections of the RESPA and TILA rules and get things like periodic statements and the right to dispute errors and apply for loan modifications, you do have to be a confirmed successor in interest. And you are confirmed once a servicer has confirmed the successor's identity and ownership interest in the property, and provided that it was one of those transfers that we just listed. And there is no requirement that they assume the mortgage. The Bureau was totally clear in the regulations that if you are a successor in interest and you document your ownership interest and it was one of these transfers, now you're a confirmed successor in interest and you are a borrower for purposes of this federal law that gives you certain rights, even though you're not a borrower on the loan, even if you have not assumed the loan. Next slide, please. Okay, and there's a couple really important things in another section of RESPA. This is the Policies and Procedures section, 1024.38, and it says that mortgage servicers have to do certain things. First of all, if they receive notice of the death of a borrower or any transfer of a property, they have to promptly facilitate communication with any potential or confirmed successors in interest. And upon receiving notice of the existence of a potential successor, they have to promptly determine the documents that they reasonably require to confirm their identity and ownership interest and provide the successor with a description of those documents. Next slide, please. And there's another section here, which is once the successor sends in those documents, they have a duty to promptly notify the person, look at what they've provided and say, either we have confirmed you as a successor, or we've determined that we need more documents, or we've determined that you're not a successor in interest. So they have these obligations to be reasonable and to respond to people who are in this situation and get them confirmed. Next slide, please. So this is a really important issue. The regulation says the documents that the servicer reasonably requires. And unfortunately, we're still seeing a lot of problems in these cases. And I bet you are too, because it's one of the #1 issues that NCLC hears about from legal services attorneys and housing counselors is, my client inherited this home and we're trying to talk to the servicer and they won't talk to us. And we've sent in the death certificate 10 times and we've sent in the other documents and they're still not talking to us. And so it raises the question, what is a servicer allowed to ask for? What is reasonable? The CFPB said that what they ask for has to be reasonable in light of the laws of the relevant jurisdiction, the laws of this state, the specific situation of this person, and the documents that are already in the servicer's possession. Next slide, please. And so what that means is sometimes it's not reasonable to demand a probate court order, for example. And that's what we often hear about is the servicer is telling me I have to have a probate court order. Well, what if you have two people who owned a home and on the deed, they had a joint tenancy with right of survivorship or a tenancy by the entireties? And I know these are legal terms of art, but I hope that y'all are familiar with the fact that sometimes two people can be on a deed with what's called a right of survivorship or an entireties deed in some states. The entireties is for married couples. And the idea of that type of deed is that the ownership automatically passes upon death, and there's no need to probate the estate. Or in some states, you can have an heirship affidavit or an affidavit of descent. that says there was no will and here were the heirs at law. And sometimes that is sufficient to show the ownership interest under applicable laws. And then sometimes in divorces, we hear, oh, you've got to get a deed from the ex. Well, sometimes the divorce decree specifies that the property is hereby transferred. And in many states, that can be done through a divorce decree. So just to flag the fact that the servicer may ask for things that don't exist or are not reasonable. And it's really important to push back when that happens and to file a complaint with the CFPB and to escalate and go up the chain, because many unrepresented homeowners are getting the same runaround. And it's a really big problem. And you as housing experts have the ability to say, this is not correct. And you probably want to talk with an attorney as well. Hopefully you have a relationship with the legal services attorney. If you don't, you can reach out to me and I'll help connect you with someone in your state. Title attorneys can also be very helpful on these issues, and probate attorneys. But if you're familiar enough with the laws and the attorney is telling you, we've given them what we have, we've given them what's reasonable, then it's really important to push back if the servicer asks for things that are not reasonable. Next slide, please. Okay, so what do you do if the servicer is being unreasonable? I mentioned escalating internally. To me, that is asking to talk with a supervisor, or I know that NHRC also has a list of escalation contacts at the various servicers. So you're trying to go up the chain to a person with more authority. And you might even ask, can I talk with the person who has oversight over successor and interest issues for you? I recently had a conversation with the person at Mr. Cooper, who's in charge of reviewing all of their successor and interest requests. She's extremely reasonable, and I may get flooded with emails, but if you have a Mr. Cooper problem, I've got a contact for you. And I know that Ellie has tons of contacts at all the servicers. So you need to go up the chain of command. It's also not a bad idea to send a notice of error, which is a kind of qualified written request under RESPA. If you're not familiar with that term, it is kind of a legal term, but you could find some basic information about it, and it's fine to tell the borrower, if you want to send a notice of error, you could say, I'm notifying you that you've made an error by not confirming me as a successor in interest. Here are all the documents I've already given you. Please correct this error immediately. And then if the servicer doesn't comply, there's at least an argument for a potential legal claim against the servicer for damages and attorney's fees. And you're just trying to get them to do the right thing. Filing a complaint with the CFPB is also extremely important. And you do that at consumerfinance.gov and then click on the complaint portal. The CFPB needs to hear about these problems when they are happening. And what happens is the servicer gets notified of the complaint and has to respond. And sometimes it puts it through to somebody on a higher level and they fix it. A lot of times it does not result in things getting fixed, but the CFPB is looking for patterns. And if they see, okay, we've got 100 complaints in the past month about so-and-so servicer, then they can go do an enforcement action and get it fixed. So please file these CFPB complaints. And then you also can escalate it with FHA, with the National Servicing Center, with Fannie Mae or Freddie Mac if they own the loan, and with the other investors. If it's a VA loan, it's a good idea to check with the VA representatives that are available. So escalate with the investors as well. Next slide, please. All right, I'm going to turn it to Lisa to talk about loan modifications. And before you do that, Lisa, let me just say this. I said before that you're helping the borrower think about whether to assume the loan. The best reason to assume the loan is if the borrower needs a loan modification. If they need a loan modification, they're going to have to assume the loan because they have to be a party to the contract in order to modify the contract. That's typically the position servicers take, and I think there's a reasonable argument for that. However, they should not have to assume the loan in advance. They should be able to apply for a loan modification and do those things at the same time. And Lisa, let me let you take it from there.
Great. Thank you. I hope that my camera is working. I can't actually see myself now.
You're good.
Okay. So let's go to the next slide. So the real question when we're dealing with someone who has a house that was owned by somebody who's deceased, and the deceased person is on the loan that is on the house, is what kind of loan is this? Because there are different rules They're very similar in this context, but there are different rules that you need to be aware of. And I know people are needing to go to the HUD meeting. This is going to be recorded, so you'll see it later. No need to apologize. We totally understand. So really important. And I would just say as an aside that it's always really important to know what kind of loan somebody has. This should be absolutely one of the first things that you look into when you're helping someone, whether it's a successor issue or other mortgage delinquency or trying to get half assistance, any of these things. It's really important to know what kind of loan they have. And there's some information here about how to figure out if they have an FHA, a Fannie Mae, a Freddie Mac loan. Of course, there might be VA or USDA loans too. And I don't think they're in this slide deck, but NCLC has on its website information about how to figure out, what kind of loan your borrower has, and always really, really important. So for purposes of a successor, it's very important because, as I said, there are specific rules, and we can go to the next slide, that will depend on, what kind of loan you have. Can we go to the next slide? Thanks. So if it's a Fannie Mae loan, they basically track this list essentially of exempt transactions that Sarah was discussing earlier under that Garn-St. Germain statute. So it's going to be, interfamily transfers and transfers upon death and things like that. And there has to be communication with the new owners, as would be required under the RESPA rule that Sarah was talking about. And the important thing is that a loan modification request that is made by this new owner who has inherited the house, covered by one of those exempt type of transfers, has to be evaluated as if it came from the borrower. So there should not be limitations on any certain type of modification that can be available. And when we get to FHA in a moment, Sarah's just going to flag one slight exception to that we're currently dealing with. But for the most part, if you're dealing with a successor and they have their paperwork and everything, they should be, if they're applying for a loan mod, reviewed as if they were no different from the original borrower. And then we've given you the citation to where you can find this information. But again, Sarah and I and others at our organizations are always happy to field questions or help share those resources with you. Next slide. Freddie Mac also allows for this simultaneous modification and assuming the loan after the transfer. And this is just where you can find that information. And then next slide. So for the FHA rules, again, it pretty much plays out the same way, meaning that if somebody meets these requirements, and these are generally going to be the case for all loans, they have to be occupying the home as a principal residence. It does say they have to submit to a credit review, but that's not the same as the review you would have if you were applying for a loan, in the first instance, a new loan. This is really more like the review that happens when you get reviewed for loss mitigation of some kind, and they have to, have the income to qualify for a loan mod. And then again, they have to be willing to assume personal liability. And as Sarah said, if we're not in the situation where you need a loan modification for this person, the question whether to assume is much more of a choice, and they may not want to. But if they're going to go for a loan mod, they are going to be required to assume as part of that whole transaction. So let me let Sarah just mention one little wrinkle for FHA loans.
Thank you, Lisa. And I saw Christy put the link in the chat to the FHA handbook, which is great, and the Fannie and Freddie servicing guides. And the additional wrinkle is that since FHA rolled out its COVID loss mitigation waterfall, which is now the waterfall for everybody, that is a streamlined process. I'm sure you all are familiar with that for FHA loans, You don't have to submit a packet of information. You don't have to give proof of your income. However, FHA is not comfortable with that process for successors in interest. And NCLC and NHLP have been talking with them about this. We think that's wrong. We think successors should be able to get streamlined loan modifications. But for now, FHA successors have to get the FHA HAMP modification, not the recovery modification, which most everybody else is getting. And that's in a mortgagee letter, which I think Christy is going to put in the chat. It's mortgagee letter 2023-11. Because you may recall that they had retired FHA HAMP or suspended it and made everybody go through the COVID waterfall, even if you have a non-COVID hardship. But now the difference is if it's a successor in interest, they need to apply for FHA HAMP, which does require proof of income. Now, the terms of the loan mod are going to be pretty much the same, but they are going to have to submit a complete packet, at least for now. Thanks, Lisa.
Yep. There's always something we need to be convincing them they're not being reasonable about, but we do have good conversations with people at FHA, but it continues. Okay, let's go on to the next section. You can skip this slide. I just want to talk for a moment about the Homeowners Assistance Fund and how eligibility works for successors. The main message I want to get to you here, and unfortunately I can't sort of speak to every single state that you are working in, but is that there is a variety of answers to, is a successor eligible? In a basic way, a successor definitely should be eligible to get the Homeowners Assistance Fund assistance if they're otherwise eligible, just as if they were the borrower on a loan. And if there's no loan on the house, they should be eligible, if there are other types of assistance like property tax relief or things like that available in your state's HAF program. But many of the HAF programs we have been seeing, and my colleague Stacy Tutt has been tracking this very, very closely, actually require like a deed that is a proof that the transfer has actually happened. Other programs, and I know DC is one of these, Pennsylvania is one of these, California sort of is, it's a little murky here where I am, but they will allow more flexibility and recognize that there are people who have what we lawyers call equitable ownership. So it may not show up in the official recorded deed paperwork yet, but they do have a true claim sort of in, equitably, meaning just fairly or reasonably to ownership of the house. And they will allow alternative documentation, which can be affidavits of heirship or other, maybe the will. In California, where I practice, we have very frequent use of inter vivos or living trusts as opposed to just wills. So that in itself, if somebody shows up to apply for HAF and is the trustee of a living trust that owns the house, because the house gets transferred into it, they might be able to show that to a given HAF program. So the important thing that I want you to take away about this issue is you need to know what your HAF program's rules about successors are. What will they accept? What do they require? And if there is a situation where the client you're working with has a very strong claim to really be the owner or be becoming the owner of the property, and you want to push it beyond what the HAF program is saying they're willing to do, my colleague Stacy and I are always happy to go to bat and talk to HAF administrators. We've been able to get some flexibility in some places, can't promise, but my contact information is at the end of this. So just keep that in mind. But it's important to understand in the first instance what they're going to be looking for and what they'll require. Next slide. So in terms of working with a successor who's trying to get HAF, these are just my sort of baseline practice tips. One is it's really useful to have, as Sarah said, a relationship with legal services or some other legal resource that you can refer your client to so that they can help. Because, you know, as you heard in the initial part of this presentation, these can be really complicated, kind of tangled situations, even with one generation. So you may need a legal eye to look at the paperwork, to look at the situation and understand what is the actual ownership status that somebody has today and what steps are going to be necessary to clear the title or make sure that they are clearly designated as the new owner, so that they can access this and as they mentioned earlier, other types of relief that may be available to homeowners. The other thing I would say is, if you can, if it's possible, getting your client confirmed as a successor by the loan servicer, if there's a mortgage that you're dealing with, and this is the process that Sarah just discussed, is really, really useful. You want to do that if possible before, or at least at the same time that they're applying for the HAF assistance, because many HAF programs also would like to see that confirmation, and it can take some time, as I'm sure those of you who've tried to do it have experienced. There can be a lot of back and forth. And it also is going to help avoid the case where the HAF program may accept the person and say, sure, we'll treat them as a successor, but then they reach out to the servicer to get information about the loan, and the servicer says, we don't recognize that person, and they just object, and then the process stops there. So making sure that you also take care of the servicer side of things, even if it's just HAF that somebody's looking for, is really key. Next slide. So these next couple are just talking about some other options that are available to successors. And Sarah, do you want to talk about these?
Yeah, that would be great, Lisa.
Okay.
Let me chime in on these, and then if there's anything you want to add, you can jump back in.
Sure.
So we just want to mention bankruptcy as a backup option. I'm sure most counselors are aware that a Chapter 13 bankruptcy can be a good way to stop a foreclosure if the homeowner is struggling to get a loan modification. There's two major types of bankruptcy that applies to consumers. Chapter 7 is the straight discharge of debt, mostly good for unsecured debt like credit cards, medical debt. Chapter 13 involves a payment plan, and for a mortgage that's behind, it allows the homeowner to set up a repayment plan for 3 to 5 years long and catch up on the back payments. The important thing for you to know is that a successor in interest can file a Chapter 13 bankruptcy and treat that mortgage through the Chapter 13 plan. The definition of a claim in bankruptcy is very broad, and it includes loans that are secured by the debtor's property, even if they're not personally liable. So Chapter 13 bankruptcy is the backup option that heirs should have if they can't get a loan mod or if there's a looming foreclosure date. And of course, the automatic stay can stop a foreclosure sale even, you know, the hour before or the day before foreclosure. Obviously, you don't want to let it get that close. And the big caveat there is making sure a person doesn't have multiple bankruptcy filings, because if they have one or more bankruptcy dismissals in the past year, there are some limits on the automatic stay. But if you have a client in your office who's never filed bankruptcy before and they have inherited the home, they can file a bankruptcy. It is a good idea to notify the foreclosure law firm and say, because they may not have a deed in their name. They need to say, I have an ownership interest in this house. Here's my proof of that. Here's my bankruptcy case number. Do not proceed with this foreclosure. Contact me immediately if you have any concerns. And that way, if necessary, the bankruptcy attorney could have a hearing in the court just to confirm that the stay prevents this foreclosure. But in all the times when I've done it, I've never had an issue. The foreclosure law firms typically realize that they need to stop and get permission from the bankruptcy court. But you do want to put them on notice and make sure that they're not going to go forward. Next slide.
And I would just add to this, if this is something that a client of yours is considering, please refer them to a lawyer to do the bankruptcy. Chapter 13 in particular is very complicated, full of pitfalls, it is not something that people should be filing what we call pro se or on their own. So while this is really a useful and important tool as a backup, of course, they do need to do it with a lawyer to make it work for them. I've just had seen a lot of disasters come in after the fact of people who tried to do it themselves.
I totally agree, Lisa. And just for folks to know, the bankruptcy attorney's fees get put into the bankruptcy plan. So most attorneys will start a Chapter 13 case for very little upfront, the $300 filing fee or, a few $100s, and the rest of the fee gets put into that bankruptcy plan. So always have people go to a bankruptcy lawyer. Next slide, please. We said that we would tell you how reverse mortgages are different. So this is our 2 minutes on reverse mortgages. And if there are other questions during the Q&A, we can take it up. But everything we said about successors being able to stay and pay does not apply to reverse mortgages. The Garn-St. Germain Act actually has a carve out for reverse mortgages. So the rule about reverse mortgages is they become due and payable at the time of the borrower's death, or these certain other triggering events like a sale of the home or failing to pay the taxes and insurance. So when the borrower has died, the reverse mortgage will have to be paid off by the heirs, either by selling the house, refinancing, or they can do a deed in lieu of foreclosure. That's an option, but the heirs will not be able to stay and pay. Now, if you have a non-borrowing spouse of the borrower, there are some special protections where the spouse can remain in the home until their death. And if you have those cases, please reach out, because there are some things that have to happen, some boxes to check, but the spouse can stay in the home. Other heirs will have to satisfy the reverse mortgage, either by refinancing or selling. And they do have the option to do either a short sale or a short refinance, selling the home for 95% of the fair market value if the balance on the reverse mortgage is now higher than what the house is worth. They can satisfy the loan for 95% of fair market value. Next slide, please. All right, and then the final thing we wanted to touch on is property tax foreclosure. In addition to mortgage foreclosure, another issue we worry a lot about with heirs and heirs property is the risk that the home might be lost to a tax foreclosure. And so it's really important, if you have homeowners that are heirs, first of all, making sure that they have the homestead exemption in place. Oftentimes that drops off after the death of the prior owner. And there can be challenges with getting the property tax assessor to allow the heirs to get the homestead exemption. And NCLC has an issue brief about this, where we talk about that these laws need to be improved and the processes need to be improved to make it clear that heirs can get the homestead exemption. But just encourage you to help those homeowners. Some of them might be able to get half assistance, or they might be able to do a Chapter 13 bankruptcy, to catch up on the tax arrears. But they need to be aware of the property taxes, make sure they're getting notices, and act quickly to make sure it doesn't go to a tax foreclosure sale. Lisa, is there anything you wanted to add on tax foreclosure or anything else? No?
I just want to say one thing. I mean, this may come up in the questions, but in the Carrie and Elizabeth's initial presentation, they talked about the importance of estate planning. And I just want to emphasize that here, that especially because I know you guys are not only seeing people in these crisis times of mortgage delinquency or facing foreclosure or something, but you're also doing, pre-purchase counseling. That is a really great time. And I think there's some discussion at HUD with their department there, housing counseling, of kind of working this into more usual protocols. But that is a really great and important time to educate your clients about the importance of estate planning. And for you yourselves, it's really useful if you can cultivate some relationships with legal services that have estate planning. There are not that many of them, but there are some. Or just, maybe some volunteer attorneys in your area who do estate planning and might be willing to either take referrals or provide you with some basic information about, the laws locally. Just you can avoid so much pain and suffering if you help people take care of this at the front end. It really makes a difference. and feel free to email us.
All right, it looks like it is time to go to Q&A. And you answered one of the questions right away. Somebody wanted to know if they could get your contact information because their local legal aid is overbooked. So I think if you, Sarah and or Lisa, if you could pop your email addresses into the chat, that would be great. Because that slide is gone. And Lisa, I have to ask you this question first because I think you're going to chuckle. But somebody wanted to know if you could get Florida to reopen their HAF program.
I wish I could. I can't even get Florida to pick up the phone and talk to me about their HAF program. I had 2 or 3 conversations early on, and then apparently they didn't like the questions I was asking. And so they basically just stopped responding. So we do talk to the Treasury Department about the Florida program, but it's a bit of a lost cause, I'm sorry to say.
Okay. All right. So the first question. If a family wants to force a sale, is that typically determined by the court system?
Yes.
Yes. Yeah. I think they have to, in most states, it's called an action for petition in Pennsylvania, but similar things in other states happen. But yes, it's a process is generally to file a petition or a complaint. And then they're specifically asking for the court to generally sell the property and split it between the owners.
Okay. One of the things that I want to tell folks before they're off, Christy's going to pop this into the chat, but Lisa and Sarah did a really in-depth session with us on successor and interest back in 2021, and it is still valid. A lot of the stuff that was talked about today is also talked about on that webinar, but it's much more in-depth. And you can view the video. It's again, Christy's going to pop the link into the chat. And just Lisa and Sarah, I'll let you know, when I was checking it out this morning, there's 1,500 views on that video. So now I'm sure there's going to be a whole lot more.
That's great.
Are there monitoring services offered in Maryland? Does anybody know?
I do not know if there's the deed monitoring. Hold on one second. Deed monitor. I don't know that. I can look that up and provide the information though.
Okay.
As we're going on.
A lot of times too, it does depend, on what's offered county by county. It is also, I serve on the board of the Property Records Industry Association, and we have been encouraging counties to utilize the service. As I mentioned, there's been legislation, but it's also good too, if your county doesn't offer it, as housing counselors, to recommend that they offer it, because it is often built into the software that they're already using. So they can, potentially make that, enable that, and make it available to constituents.
I would like to point out that there are certain companies that purport to lock your title or offer a service like this before your clients actually purchase something like that. They should check with the county to see if that's already offered, basically.
And along those same lines, so let's say a homeowner or heir receives this notice. What are the steps to address that and to remove the unauthorized recording?
Unfortunately, it generally involves a legal action and getting to an attorney that can file something called a quiet title action. I think that's what it would be called in most states. But essentially what it is an action that says, hey, that deed was a fraudulent deed or a forged deed. Court, please strike off that deed. And then if you're successful in that, it results in a court order, which court order should generally be recorded so that we can see it when we're searching the records. So the court records are separate. In most places, court records are separate from the land records where the deeds get recorded. So a lot of times it's important to make the two talk to each other, and you do that by recording orders of the court.
Okay. Let's see. Any recommendations for low-income homeowners to do estate planning? Could you do it yourself online? When they say do it yourself online, I'm not sure if they're talking about themselves or asking you all. I'm not clear from the way the question is.
Well, I'll just say, I mean, I would always recommend that somebody get legal assistance doing it, if at all possible. There are complications, it's different state to state, and there are tax implications and different things that somebody needs to be watching out for. If the home is the only asset, it shouldn't be a hugely expensive, proposition to get legal assistance. I mean, there's a range of fees that people add. As I mentioned, there are more increasingly legal services or volunteer panels that are available to help. I know here in California, organization I used to work for, Housing and Economic Rights Advocates, provides sliding scale, sort of from free to low cost, depending on income. And I think there are other models coming out now. There are tools online to do estate planning. And I will admit that I once used one, but then I later went back and took it to an attorney and had them look at it, even though I'm an attorney. So that just tells you how important I think it is that you have somebody trained in this area, at least look over paperwork, but ideally generate it for you. I understand it's always, a balance of cost and benefit of, weighing that outlay for whatever it's going to cost, but it saves so much time and expense later for your heirs and for the family if you have gotten these things set up beforehand.
I would note too, by the way, I'm a lawyer, as is my husband, and we had an estate planner actually do and we don't have a terribly complicated thing, mostly because we're still, under student loan debt, but we too still had a lawyer. In addition, I know in the Northeast and particularly Pennsylvania, there are a lot of bar associations. There's county bar associations that will offer these programs for once in a while, particularly through the Young Lawyers division of it. And I think there's still a Wills for Heroes is what it was called. I think this was started after 9/11, this initiative. So irrelevant of what they make, if they are a first responder in some way, they might be eligible to attend one of these, not a seminar, but a day where there are volunteer attorneys there to write out basic wills for first responders. So that's still a program too. I really would recommend reaching out to the local bar associations, because there are a lot of programs out there that you might not be aware of that offer pro bono services without doing the whole going to a pro bono agency.
Great. Okay, so the next question. So Carrie, I think it was you that mentioned a study in Philadelphia, a Pew study, and one of the attendees actually found the link and shared it with me, and I posted it in the chat. But this person also asked, do you know if there are any other studies for other areas?
I'm not familiar with other studies in other areas, no. Elizabeth, are you?
Yeah, so it's not our study that's coming out, but I do anticipate by the end of the year there will be a national study out that helps sort of quantify the amount of specifically residential real estate that is considered heirs property. So that will be likely a baseline number, meaning that there's likely to be significantly more heirs property than what's reported, but we should have at least some numbers out there to help with advocacy. So watch for more information in the news on that towards the end of the year.
Great. And Elizabeth, if you get access to this, please send it along to us and we'll get it out to the listserv. And speaking of the listserv, if you want to know more about all of this kind of information, you want to hear about our webinars, and you're not already on our email listserv, I did pop the link into the chat for you to sign up to our email listserv. Okay. Somebody just mentioned, I think it would be helpful if wills and trusts were required to be recorded to help protect estates and heirs.
I would say that might be helpful. but most people don't want to produce a lot of their estate planning documents, particularly if they've ever used a trust. At least that's been my experience in requiring them. So it might be helpful for that, but I can't imagine a situation where that comes into place.
I think the other sort of constraint on that is that although we're talking about the, creation of an estate plan as kind of a one-time thing, if you're doing that when you're 40, it is worth looking back. This is the next step, at the trust or at the will and other documents, every few years, because life circumstances change. You want to be sure that the people who are going to be executors or trustees are still alive, still have capacity. So all I'm saying is there can be changes to these documents that need to be made. And so if they had to be recorded again and again, that could get messy and expensive.
And I would say that from a title insurance perspective, it might muck up the title a bit in terms of causing exceptions to be taken. I know, so I could see some problems with it too. Yeah.
And I can speak personally to what Lisa just said, that my husband and I did estate planning probably 15 years ago, and we had to just redo it this past year. So good point. Is a beneficiary deed a good thing to do?
So when people reference a beneficiary deed, these things go by different names in different states. And I would just say there are some states that have something called a ladybird deed. There are some states that have something called a transfer on death deed. So those can be useful tools, but it really varies state by state. The idea, at least behind a transfer on death deed, is that it's a way of not having to do probate. And I believe transfer on death deeds are allowed in about 29 states. And so at least NCLC thinks that's a really positive thing if it's available in your state, but I'm not sure if beneficiary deed might mean something else. And Carrie, did you have anything to add on this point?
Yeah, we've seen the ladybird deeds. We also call them South Philly trusts here. Because it was very popular in South Philadelphia to do this for some reason. But so that's another fun deed. I will say that at least in Pennsylvania, and you should consider this anywhere where there's estate and inheritance tax, it doesn't resolve all the issues. You still will likely need to pay inheritance tax on it. The other thing I would say is that it's complicated because I think some states don't say that ladybird deeds aren't valid anyways, including Pennsylvania. There's some question about that. So we might treat it as a life estate with someone having a remainder anyways. So I don't know. And that's just from a Pennsylvania perspective. I will say that, and I like this, I kind of make this joke all the time, don't take advice from Facebook, because I've seen this post about due on death deeds splash across Pennsylvania, and people in Pennsylvania share it. And I always want to scream out, that's not something we do in Pennsylvania. So I think while there are benefits, it would depend on the state, and certainly ask a legal professional in your state whether or not that is something that can be used.
Okay, so before she has to leave, I just want to say thank you to Lisa Sitkin. She has to jump to another presentation. So thanks, Lisa, for taking time to be with us today.
Thanks, everyone. Take care.
Okay, so one housing counselor wanted to know if it would be considered legal advice if they provided a list of necessary documents for their foreclosure clients, so that they know what to ask an attorney for.
So I think this question's a little, I think it could mean two different things. If they're trying to give the client a list of things you should gather to go talk to an attorney about how to clear up your title, I think that could be reasonable and probably would not be legal advice. But I think if you're trying to, I do think anywhere in this ballpark, you're in kind of a gray area, and you should talk to an attorney in your state. If it's a list of documents that you need to get together in order to get the mortgage company to talk to you, it's got to really be from the mortgage company and involving a lawyer, I think. But again, I'm not totally sure. But I have heard people talk about what documents to gather for your first meeting with a probate attorney. And I think that kind of thing can be helpful for non-attorneys to help people prepare a family tree, you know, get the obituaries and death certificates together. Like, I don't think it's legal advice to suggest those kinds of things.
Okay. Not sure. I think that this question is a response to something that one of you mentioned. So maybe you'll remember what you talked about that is related to this question. Due on sale clause and rehab loans or down payment loans?
I saw this one, so I was starting to think about it. I think the question is, you know, do those type of loans come due based on a due on sale clause? And I think they probably do, but the issue again would be, is it an intra-family transfer? So if you have like a silent second mortgage for home repairs or down payment assistance, there probably is a due on sale clause there, because the whole idea of those silent second liens is to recapture the money if there's a sale of the home. But I believe there should, you know, that they shouldn't be enforcing it if it's an intra-family transfer. That's the best of my knowledge. Anybody want to add anything on that? So, yeah. So they probably should not come due if it's a family transfer covered by Garn St. Germain.
Okay. This person has a client that inherited a home from a client where she provided caregiving. She's not family. Does this protect her?
So technically, that person is probably not a Garn exempt transferee unless she was added to the deed with a right of survivorship before the death, because the categories are very specific and it says transfer to a relative from a death. And she's not a relative, but the other one is transfer via a right of survivorship in a deed. So if she was already on the deed as joint tenants with right of survivorship, then she could be protected under Garn St. Germain. And if not, then she wouldn't be. But even if she's not technically covered by Garn St. Germain, a lot of times the mortgage company will let people just keep making payments if you're making the payments. It's just, you don't technically have the protection of these laws.
All right, so I think a lot of the people who attended this presentation were pretty familiar with this, but I guess it bears repeating again. But this person wanted to make housing counselors aware that servicers don't make it easy to get recognized as a successor in interest, and it's hard to get the information to file a successor in interest.
I agree. And I'm sorry, it's so difficult. This is one of the areas where housing counselors are so important, and attorneys. And so please keep on helping these homeowners, because you're right. Without you, they're not going to get approved. It's unfortunate. And hopefully if we keep filing CFPB complaints, we can make some more progress on it.
And if it makes you feel any better, it's also impossible for us to get payoffs on loans that we actually want to pay off a lot of times. So you're not alone. And I know that's not the best answer, but you're not alone, at least.
But that's a great point. Yeah. The title companies are like, we need a payoff quote. And I bet you do have difficulty a lot of the time. Yeah. But once they're confirmed as a successor, they have a right to a payoff quote, you know, within 7 business days. But we have to enforce those rights.
So along the same lines, I'm skipping a couple of questions, but because it's along the same lines, I'm going to jump to it. Successors in interest do not apply to HELOC mortgages. You cannot file a complaint with CFPB on successor in interest if your name is not on the promissory note. Servicers will not respond to the complaint. This has been brought to the attention of CFPB to change the process.
So I'm a little confused about that one. There is an issue about HELOCs, home equity lines of credit, are exempted from a lot of the servicing rules in RESPA. So I don't believe it's technical. I think well, no, I guess it is true that you would not be able to be confirmed as a successor on a HELOC. That's something NCLC has been pushing to change. But you still can file a CFPB complaint, I believe, and successors in interest should, and their third party authorized helpers should file those complaints.
All right, well, we'll see it. We'll see if something else pops into Q&A in response to what you just said. How can a housing counselor advocate effectively when a successor in interest has been established with divorce decree and quitclaim deed already, and yet the servicer is still requiring the original borrower to provide their documents for a loan mod?
So this is probably another one for me. I think that sometimes divorce situations are the most difficult. And the reason is there is still a borrower on the mortgage who is alive. And usually what's happening is the spouse that's living in the home it wants to get the loan modification. And sometimes the servicer will say, we need the ex to participate, which is problematic. In general, they should be able to get recognized as a successor in interest. Like in the typical scenario is husband and wife, and let's say wife gets the home in the divorce, but she wasn't on the mortgage. If she received the home through a divorce or separation agreement, she is a successor in interest. And so it's the same thing about escalating, pushing. And then if she needs a loan modification, then she needs to argue that under applicable investor rules, FHA, Fannie, Freddie, that she can get that without the ex participating. But there are still some hiccups there. And feel free to email me about particular cases.
Do VA loans have any further stipulations regarding surviving spouses who are not on the deed or mortgage?
I think these issues are trickier with VA loans. I haven't had to address it specifically, but I think the rules around assumption and modification are not as clear because it's a benefit that is meant for the veteran. So if the spouse is not a veteran, I'm not 100% sure that they can do an assumption and modification. But again, in particular, if you have a specific case, certainly feel free to reach out and we'll try to dig into that issue.
Okay, as a couple of bankruptcy questions here. The Chapter 13 bankruptcy filing would be to only set up a repayment plan for the past due balance, not the full balance of the loan. They would then still have their regular mortgage payment to also stay on top of?
That's exactly right. And it varies jurisdiction by jurisdiction how the payments are set up. But in general, when someone files a Chapter 13, they're supposed to start making their regular payment on time going forward. And then that arrearage, let's say you're $10,000 behind, the $10,000 gets spread over up to 5 years of time. And sometimes you make both payments through the trustee. But in general, you have to be able to pay the regular payment going forward and the arrearage. And the purpose of the bankruptcy is just to catch up the arrearage and then let you go forward.
And does filing a bankruptcy affect the successor and interest credit history?
Oh, that's such a great question. Yes, the bankruptcy will go on their credit. And so they've got to factor that in. And for most people, if they're trying to save their house, they're willing to take that hit. You're balancing the harms. Interestingly, if you're a successor in interest, the foreclosure will not go on your credit because you're not the borrower on the loan. But if you file a Chapter 13 bankruptcy, then yes, that goes on your credit. And I believe the bankruptcies stay on for 10 years. So it's possible to rebuild after, and it still might be the best thing, but it does impact your credit.
Okay. Can a Chapter 13 be used to prevent tax sale foreclosure?
Yes. And so again, the bankruptcy automatic stay stops any efforts against the debtor or the debtor's property. So if there's a tax foreclosure scheduled for tomorrow and the borrower and the homeowner files a bankruptcy today, again, unless they've had multiple filings before, if this is their first time, then it will stop that foreclosure at least temporarily. And then they have to propose the plan to pay off the taxes because the taxing authority is a secured creditor. So they have to be able to pay it over the term of the bankruptcy. And that, again, that's if the tax foreclosure has not happened yet. So yes, it can be a really useful tool.
But I would note getting that information to the appropriate people before the sale happens is super important. It's not just about the filing. We've even seen, we've seen the sale happen and that's a violation, but they have to unwind it still because the title has a problem at that point. I've also seen where, the tax payment gets made, but it didn't get to the right person and it still goes through foreclosure. So making sure if it's a situation where there's a foreclosure happening or a tax sale happening, making sure it gets to the right person that can actually at the office that can actually stop it is really important too.
Okay. If a successor in interest was able to get a trial mod, was making payments, and now the bank is not accepting those payments, is that normal? Should the homeowner be talking to an attorney?
I do think that's an appropriate situation to bring in an attorney. So just to make sure I understood the facts, they got a trial plan, they made the trial payments, and then the servicer never gave them the permanent modification or has stopped honoring. Was that it, Ellie?
Well, it doesn't say. It just says
Okay.
they were making payment. They got a
Yeah.
trial modification. They were making payments, and now the bank is not accepting payments.
So it happens more than it should, but that is a problem because they were offered a trial payment plan. If they completed it, they should have been given a permanent loan modification. And sometimes what happens is during that trial plan, they pull a title report and the servicer says there's a title issue, but they're again, if it's one of these investors, Fannie Mae, Freddie Mac, FHA, they should be able to get that modification. So I think it's worth talking with a lawyer to sort out what happened, and to help escalate that and say, why did you dishonor that? Why did you stop honoring this trial payment plan that you approved? Because when they approved it, they should have known they were dealing with a successor in interest.
Okay. This person says they had a client ask, should I will my home to my children? And I know it's not paid off and they have their own home. Aside from referring them to an attorney for advice, what can we educate this person on?
I mean, talk to the children, I think would be one answer. Some people don't want to be burdened with another property. And I guess it depends on, do they want to, are they explicitly giving it to one or not? To me, that's beyond the law because I feel like the attorney is going to say, well, what does your family want? And I don't know that there are benefit other than, certain tax rates potentially if transfer tax applies. I don't know that there are, sorry, not transfer tax, inheritance tax or estate tax applies. I don't know that there are benefits to leaving it to a child versus to someone else. So.
Yeah, I think that's all right. And correct. And I think too that some homeowners don't realize that your heirs can still inherit your home, even if it's subject to a mortgage. It's just, you'll have to deal with the mortgage. And if they don't want to live there, they could sell the home, pay off the mortgage and keep the equity.
Yeah, because even if you give, and so even if we see a will that says I'm giving it to child A, explicitly this home, it can still be sold. It's just child A has to sign off, generally speaking. So in addition to the executor, etc. So it can still be sold. It doesn't, leaving it to one person doesn't limit the options. So I think it's all a personal choice.
Okay, I think that this is a follow-up to the question about, is this considered legal advice if I provide some documents? This person says, what about telling the heir that that these are the successor and interest process options and you need to talk to an attorney to find out which one applies to your situation?
I think that's fine. I think that's providing information, not legal advice. And I also think it's good to refer people to the CFPB's website, which has a lot of consumer facing materials about home, protecting your home, passing it to heirs, that type of thing. But yeah, I think just saying, here are the types of situations that can arise is totally fine. And some next steps.
Okay, and this is the final question. I know the panel touched on this, but the transfer on death deed, would you say that could be a better option than a will or trust for ownership purposes? Or what would be your thoughts on this?
I really like transfer on death deeds, and I know what Carrie means about they can't necessarily be used in Pennsylvania. I think Pennsylvania, by the way, is really unusual in having state inheritance tax. I'm not aware of any other state. Yeah. But in the states that
I think New Jersey might have some too.
Okay.
Depending on the size, but yes. Yeah, we're special. So.
Yeah. So that makes it problematic in Pennsylvania, and you need to check to see if it applies in your state. But the benefit of a transfer on death deed is that it avoids probate. And if you have a will, you have to probate the will by filing a lawsuit and serving all the heirs at law. So if there are, 10 people who would have inherited the home if there was no will, they're all entitled to be served with the probate action, and you have to find them. And it's just a headache. So if you have a transfer on death deed option in your state, I think it's really, really great. And so, actually NCLC is working on an issue brief about transfer on death deeds and listing the different states. And Ellie, I can send that to you when we have it.
Yeah, and I would say, you know, that's something too, our work group at Alta is looking at, you know, what are the easier ways to sort of do estate planning, you know, where you can avoid some of these probate processes, and it can be more accessible to people, because the estate planning piece is so great. We spent so much time talking about all of the problems and the aftermath today, which is important, and we have to address those. But if you can stop all of this with accessible estate planning, it is just beneficial all around.
I would note too, I mean, I think I critique my state a lot, but there are options. There might be, even if you don't recognize it, your state doesn't recognize a transfer and death deed, there might be other options in terms of ways to hold title. For example, you could do a deed transferring it to yourself plus someone else as joint tenants. In that way, the property will go to that other person. In Pennsylvania, it still has inheritance tax implications potentially, but that would automatically go to the surviving person. If they're husband and wife, and one dies, and they hold title as husband and wife, it again just becomes the other spouse's property. And there's potential for, you know, life estates too, where you do a deed where you reserve a life estate, meaning the right to live in the property for your entire life, and then name what's called a remainder, which is the people that will take it after the death, which is how we often treat, I think I mentioned this, but the South Philly Trust, or the Lady Bird deeds, that's how we often treat them. We treat them as life estates subject to, with a remainder subject to a life estate. So there are other options besides the transfer and death deed. It sounds like the transfer and death deed is an amazing tool that I cannot imagine us ever recognizing in PA just because of the legislative problems here, but there are some other options. So if you can get an attorney to describe all those different options, even when a transfer on death deed is not available, there are some options so that you can avoid having to raise an estate.
Great. Well, thanks so much, all of you, for your time today. I hope you've been paying attention to the chat. So many people talked about what great information this is and how helpful it is. I will say to those of you left on the webinar today that last week we had a webinar with David Berenbaum, and he was talking about all of the different ways that they're looking at defining housing counseling and kind of expanding things. And one of the things they're also looking at is what are other items that we ought to be paying attention to. And I brought it up, and then several of the housing counselors brought it up as well. The successor and interest in tangled title issue should become part of the pre-purchase counseling format, just as part of the process, as part of the pre-purchase education and counseling. So with that, again, thank you to all of our panelists, and I'm going to hand it over.